My name is Lorena Roel. I'm a real estate attorney with Brewer, Offord, and Pedersen, and today we are going to talk about deposit disputes. So first slide is our disclaimer that I'm not providing legal advice and this is entirely for educational purposes. So I'm just going to leave that up there for a minute for everyone to have a chance to read. Okay, so let's get started. And a picture of me. So we're going to get started on the basics of earnest money deposit. So I want to briefly talk about the differences between a down payment and an earnest money deposit, because in real life, a lot of people kind of conflate the two. You hear a lot in California that people need to save 20%. I need to save 20% to buy a house. I don't have 20%. I only have 10%, all of that. And what that person usually is meaning is that they have money for their earnest money deposit and their down payment, which is the cash to close the deal. So an earnest money deposit is the money provided to seal the deal. It's at the inception of the purchase agreement. So a buyer submits a purchase agreement and says, I'm going to deposit X amount as my earnest money deposit to you, seller, through escrow. And the down payment is the amount of money that you've saved to pay at the close of escrow. So you're not putting it at the very beginning, you're putting it towards the end. And the reason why people get confused is because it's money that you saved, yes, and you're trying to save as much money so you don't have to take out as big of a loan. But they are used differently. So I'm going to use an example of $100. You want to buy a house for $100 and you've saved $20. So your earnest money deposit, you're going to put $2 down. Your down payment is the $18. And the loan amount that you're going to get is the remaining $80 from the bank. So what you first do is buyer would provide the purchase agreement with the $2 as the earnest money deposit. And then with the remaining $18, go to the bank and say, hey bank, I've saved enough. Will you help me with the loan? And the bank will say yes or no. In this instance, the bank is going to say yes. And, up through the close of escrow, you've already deposited your $2. You're going to deposit the other $18 at the close of escrow. The bank will finance the remaining balance, and boom, escrow is closed. Seller has their money, their $100, and you have the property. So that is the easiest way to explain the differences between the two. Well, today I'm only going to focus on the earnest money deposit, which is the money provided at the outset of the transaction. Okay, so I've talked about the differences between earnest money and the down payment. So what is the purpose of an earnest money deposit? The purpose is that it indicates to the seller that you are serious about this transaction. You really want this property, you're willing to put down X amount of money and willing to lose it in case the deal goes sour, potentially, and that you really want this. And it shows to the seller that you want the property and that they are going to take it off the market to work this transaction with you. So that means they're not going to be taking offers from anybody else. And it's also applied to the final purchase price. As I discussed in the last slide with the example, the $2 were put towards the final purchase of the $100 property. Okay, so we know when the earnest money deposit starts at the outset, and we know its reason. So how much do you provide? And there technically is no set amount. You can provide a 0, 1%, 3%, 10%, or you can make it a figure and not necessarily a percentage. It could be $1, $2,000, $10,000. It's completely up to you. Since there is no set amount required, it's just what the buyer really wants to put down, what they can feasibly put down. But it's most common that a earnest money deposit is not going to exceed 3%, mainly due to the statutory limitations on the liquidated damages clause within the purchase agreement, which I will discuss the liquidated damages clause later on. But it is pretty common for 3% to be the utmost figure. The thing with choosing your earnest money deposit amount is what I always advise is to speak with your agent. Have what I like to call the earnest money deposit talk. And I like that talk to take place pretty much as soon as you sign a listing agreement or even beforehand with your agent, because that is going to kind of set the tone for the rest of the relationship. A agent will be able to better represent you and will be able to draft a purchase agreement that is beneficial to you and doesn't put you in harm's way. So this earnest money deposit, what I really like is for a free-flowing open conversation in which the buyer tells the agent, I can afford to put X amount as my earnest money deposit. I saved, this chunk of money. I'm willing to put this amount. It could be a range. It could be a percentage. It could be a hard number. It's completely up to you as the buyer what you are feasibly capable of providing as your earnest money deposit. With that, though, a lot of people save and then put all of it towards their earnest money deposit or put all of it in their down payment. And I get weary about that because there are going to be additional expenses that you're going to incur during escrow, such as inspection costs, closing costs, fees, and other potential expenses. And you don't really know how much it's going to cost. It could be $500. It could be a few thousand. It all depends on just that specific purchase agreement and that property, its age, or what you as buyer would like to conduct on the property during the escrow period. So when you're talking with your agent, tell them at least how much you can afford, and then take off within that amount of money. Say you have $10,000 for earnest money deposit. Say I want to save $2,000 for additional expenses, which tells your agent I'm willing to do $8,000. That is a hard figure. You don't have to do 8. It's completely up to you. Again, it's your finances and what you can feasibly afford. But that's what I advise in this earnest money deposit talk, because again, it really helps set the tone for the representation, and it really helps your agent be able to do what's in your best interest with regard to looking at listings, taking you to open houses, drafting the agreement, and guiding you throughout the process. Because purchasing a property is very emotional, because it's one of the biggest transactions that people do in their entire lives. And so you don't want to be stretched in which you gave up all your money, now you can't afford these other things, and then you're stressed with credit card payments and either rent or other bills. We don't want that. We're trying to make it as smooth as possible. So tell your agent how much you have. Keep a little bit for savings for these extra costs, and let them know exactly what you can feasibly afford as an earnest money deposit. And the reason why you need to have that talk as well is because once you actually put the purchase agreement and it's accepted by the seller, you have 3 days to deposit the earnest money deposit into escrow. And that's just the default. You can change it. So let's give an example of a buyer who has had the conversation with their agent. I have $10,000 that I can get for my earnest money deposit. They're in my stock, so I have to sell my stock and then transfer the money, but I haven't. Well, buyer doesn't want to liquidate their stock just yet. They're waiting until there is actually a house that they want to provide a purchase agreement and everything like that. So it's not until they actually see a house that they realize, okay, I'm going to sell my stock and cash out so that I can throw this money towards the earnest money deposit. If that's where your money is, or if your money is just not readily available where you can just walk to the bank and get a cashier's check or do a wire transfer, then you need to tell your agent so your agent is able to add additional days to the deposit of the earnest money deposit, because it's specified as 3 days, but if you need more, it's okay. I've seen it where someone sold their stock on a Friday, got the cash in their stockbroker's account on Tuesday or Wednesday of the following week, then transferred it over to their bank account. And it was supposed to go through by Friday, but it went to the following Monday because it was a lot of money. So that is 7 days. And that's just from the day that they sold the stock. So if you need 7 days, if you need 10 days, just let your agent know, so that is part of the purchase agreement and it doesn't default to the 3 business days. And also, don't feel that because you need extra days, you need to give more of an earnest money deposit amount. The amount is set by you and the days is set by you. If you can't feasibly provide that amount within a shorter time frame, you can't do it. Don't push yourself into a corner in which you potentially breach the contract. Because that's what we're trying to avoid, is a buyer breaching a contract because they didn't deposit the amount of money on time. If they didn't deposit in 3 days, they're technically in breach. And you don't want to start off the first week of your transaction already in breach. So an open and honest conversation with your agent, who will then have it with the seller and the seller's agent, keeps the lines of communication open. And it shows that you're not trying to, breach or I want to say back out of you're not trying to breach or back out of the deal, that you reasonably want this property. You just are kind of confined by other corporations and how long they take to transfer your money. Okay, so I talked about, what is an earnest money deposit and the timeframes, the 3 days to deposit. But what I really need to do is also kind of backtrack and go back to the basics of making an offer and acceptance of such offer. So in this situation, we already have a buyer and agent who had their earnest money deposit talk. The agent knows how much the buyer can put down as their earnest money deposit. And I don't know if you just caught that I said put down. That's just the common phrase, but I too need to kind of step away from that because I believe that's where the confusion lies for some people. So to rephrase, the buyer needs to have the conversation with the agent, the earnest money deposit talk, and then they can decide how much they would like to put towards the earnest money deposit, and the timeframes. So once that all happens, buyer and agent are ready to go look at homes. And so let's just say buyer goes and tours a house and says, this is it. This is what I would like as my future home. So let's put in a purchase agreement. Buyer and agent drafts the agreement together. Mainly, agent drafts it, buyer reviews it, and then it gets submitted to the seller's agent. And at that point, the seller has three options. They can either accept, reject, or counter. So I'm going to start with reject. So if the seller rejects your purchase agreement, then that's pretty much it. It's unfortunate, but you move on and you tour other homes. It was not meant to be. If the seller counters, then they will provide a seller's counter number 1 and submit it back to the buyer's agent. And usually those counters are reflective of money. You know, they want the buyer to actually pay more money, or they want a shorter escrow, longer escrow, things like that. So it's just those little terms that they're hashing out. And once seller makes that counter, it goes back to the buyer. And so that's when the buyer has the option to accept, reject, counter. So again, we're starting with rejection. If the buyer rejects the seller's counter number 1, then there is no agreement. Buyer moves on to the next open house, and hopefully they'll find their dream home soon. The buyer can also accept it. They can look at seller's counter number 1 and say, I'm fine with those terms. I'm fine with paying $10,000 more. I'm fine with, escrow being this date instead of this date. If they're okay with it, they're okay. In instances where a buyer is not necessarily okay with the terms that was in the seller's counter number 1, the buyer can submit a buyer's counter number 1. And so that could be, again, the price or the escrow close date. So for example, the buyer wanted to purchase the house for $100, and that was the offer. Seller countered with $150. Buyer counters for $115. So, it's a little back and forth, but hopefully they come to an agreement. Seller can then counter again, or reject, or accept. And sometimes these counters can go, I think I've seen one where each party had 4 counters because it was just, getting close, but they got an agreement. So once the parties come to an agreement, either through counters or the original, then they're in contract. But if they don't, then they don't, and seller sells to somebody else and buyer goes to another open house. So we're going to talk about the seller accepting the buyer's original offer, since it's just the easiest way and gets us through my presentation, because you can't have a deposit dispute if there's no contract. So in this situation, the seller accepted the offer. And once that happens, the buyer opens an escrow account, and escrow agent is to receive the deposit within 3 days, as that's the default. Or, if you change the terms, then whatever the date is, just whatever the date it says on the purchase agreement. And so the escrow agent can receive it from the buyers themselves or from the buyer's agent. So earlier I talked about how a buyer, needs to sell their stock or, pull out money and need extra days. Well, there are certain instances where buyers just know, here's my, $8,000 for my earnest money deposit. I'm not going to give more. I'm okay with giving less, but here, agent, I've already pulled out the money. I want it in your hands, so then I don't have to be the one to transfer to escrow. You transfer to escrow. So they give that money to the agent to then tender it to escrow within those specified days. So it can be either from the buyer or buyer's agent. And most common is just electronic wire transfer and cashier's check, personal check is acceptable as well. Okay, so we are, here, let me go back real quick. So we are in contract right now. Buyer submitted an offer, seller accepted the offer, and buyer tendered the deposit, the earnest money deposit, to the escrow holder within the days specified in the purchase agreement. So we're in escrow, things are happening, and unfortunately, there's a dispute. And now we're kind of wondering, well, who gets this earnest money deposit? And the dispute can only occur once, well, not the dispute can only occur. The dispute occurs when the contract is canceled. And the contract is canceled in one scenario based on a contingency. So, contingency is mainly based on buyer's side because buyers are the ones who submit the purchase agreement with contingencies, such as appraisals, loans, sale of the property, sale of their own property. It all depends on what the buyer's drafted. So if that is part of the agreement, then it can be canceled. So this is where it's a little confusing for some people. And I was too until I've learned a little bit more about it, is that some people believe that if there's a contingency, the contract is not full-fledged. You're not in contract. You're still, working things out. Well, that's not true. The parties are in contract. They both signed a purchase agreement. And it's just these contingencies are a way out if certain things are not met, such as an appraisal or a loan. So you still are in contract. And I just wanted to clarify that because a lot of people believe that you're only in contract once all of the contingencies are released. That's not true. You're in contract from the beginning. It's just you have to deal with these contingencies as they come. So I'm going to use the loan example because that's the easiest one. Say buyer submitted a purchase agreement with a loan contingency, meaning they can only buy this property if they obtain this loan. And if they don't obtain the loan, they will exercise the contingency in order to cancel the contract. So when they do that, they have to be doing it in good faith. And technically, the entire deposit is to be returned, should be returned to them. The reason why I use the loan one is because it's pretty easy and common. A lot of people believe that because they get a pre-qualified, to obtain the loan from the bank, that they will automatically get the loan. That's not necessarily true. And, we don't want people to not have such a contingency just because of a pre-qualification. The loan is necessary because otherwise you can't afford the house because you don't have the actual cash at hand to, close the sale. So we're going to say the buyer had a loan contingency and unfortunately was unable to get the loan. the buyer has to communicate by the deadline specified in the purchase agreement that they will exercise their contingency to cancel the contract. They need to do it, by the deadline. And in my opinion, I think buyers should wait until the contingency deadline before attempting to try to waive or release a contingency, because if they do that, they put themselves in between a rock and a hard place. So same example, buyer submits a purchase agreement with a contingency, a home loan contingency. They get their pre-qualification. They're getting called into the boss's office at the end of the week. They think they are going to get promoted, going to get going to get a raise. And so they tell their agent, and they prematurely release the home loan contingency. Then buyer goes into, a few days later, buyer goes to meet with their boss, and unfortunately, company's going under, they're getting laid off, and the bank gets wind of it, and he's unable to get the loan. If buyer at that point then tries to say, oh, I would like to exercise my contingency because I can't get this loan, he's completely out of luck, because he already signed this release, meaning he can't use that as a reason to cancel the contract. And when he tries to do that, he's going to put his deposit at risk, because there is no contingency plan. He's released it, and he shouldn't have done that. So if you're a buyer and you have contingencies, communicate by the deadline that you're going to exercise it. And if you believe you're going to release, wait until the contingency has happened before releasing, because you don't want to put yourself in a situation where you are now forced to close escrow, and you don't have a home loan. Okay, so the second way to cancel the contract is by non-performance. So a party fails to perform, and it can be either party. So the examples I have are, for buyer side, is failure to deposit the earnest money deposit and failure to release contingencies. So, and with sellers, it's failure to provide disclosures within the time frame. And this one is a little bit tricky, because there are more steps than what you just initially think. So I've heard people say that you're in contract and then buyer didn't deposit the funds, or they didn't release this, so now we're out of contract. That's not true. You're still in contract up until the point that you have canceled. So how I would like to clarify is, to either party who has not been in breach of the contract, you say the other party has not performed within this time period, and so we're going to serve them a notice to perform. So the notice to perform then gives them, a few days to perform, and if they don't, then you cancel the contract. So it's not until all of that happens before you cancel the contract, and then you are no longer in contract. I know it gets confusing with the language sometimes, but I just wanted to clarify that if somebody doesn't perform within the specified time, a notice to perform must be served. The time within that notice must expire, and then after it has expired, then the contract can be canceled. So we have the two ways to cancel a contract: contingency, which is mainly buyers, and then non-performance, which is any side. It's just Whoever doesn't perform needs to perform, and if they don't, there are ways to cancel the contract. Okay, so we have canceled, whether it's contingency or non-performance. Either way, we've canceled. So what are your rights in general? Basically, the buyer who deposited the money into escrow, and the money, I mean the earnest money deposit, should get it back. And it's supposed to be returnable to the buyer, even if the buyer is the one who canceled the contract. So if buyer cancels the contract because they didn't get their home loan contingency, so they exercised the contingency to cancel the contract, or if the buyer canceled it because seller did not perform, either way, in general, the buyer is supposed to receive their earnest money deposit back. Neither party is entitled to accrued interest. So once the contract is canceled, escrow is made aware, and no more interest on the money that's in the escrow account can accrue. It's just, that is the money. So whether we are arguing it from today, a month from now, few months from now, it is whatever the amount it was at the time we informed escrow that we have canceled. And then documents provided to escrow is also returnable. I put this in there even though most of documents provided to escrow are through email. So you technically have your own, and you've provided an email copy to escrow. But on the chance that you like to go in and provide documents in hand and would like to go back and get the file, you can do so. You can go and get whatever documents you provided to them that you no longer have a copy of. Okay, so rights after cancellation in real life. The escrow agent, the escrow holder, is going to hold on to the earnest money deposit until they receive escrow instructions signed by both the buyer and seller. So that means buyer and seller must work together. And the reason for that is because the escrow agent is not going to get involved into the fight over the deposit. They're not going to make a decision on whether buyer deserves to get all of it back or seller deserves to get all of it, or they split it 50-50, what have you. Escrow agents are not going to get involved. They need to be told through these instructions who and how much to distribute. And so it is beneficial for the buyer and seller to, try to work things out and prepare instructions quickly, because escrow, it doesn't affect escrow to just keep the money in there while everyone else, kind of fights about it. It has no negative impact on them. So, well, I wouldn't say no negative impact, but it's not negatively impacting their lives as it is to the buyer and sellers who are fighting over such money. So it's best for them to work it out, prepare instructions, give it to escrow, and then get the money. So another thing, failure to execute written instructions needs to be based on a good faith dispute. So an example is the buyer and seller, the contract canceled, doesn't really matter why. And seller is just completely upset with buyer and isn't providing a reason why seller should keep the money or get any money. Just, I'm mad at that. I'm mad at buyer, so they shouldn't get anything. I should get it. Well, that's not really good faith. You need to, provide a reason on how you've been damaged, or show something so at least you can demonstrate that you are thinking about the process and trying to work it out and make your arguments known to the opposing side. If you're just stonewalling, for the purposes of stonewalling and because you're upset, you might make yourself liable to not only the amount of funds in escrow, but other damages and potentially attorney's fees if attorneys have to get involved, which you don't want to do. So if anything, it is best to just start working it out. I know it's upsetting for both sides that the contract did not go through, but you need to work together to kind of resolve this issue, because it's just going to help in your daily life. You as a seller don't want to be in this dispute with a potential buyer while simultaneously trying to sell this property to somebody else. It's very stressful. It's very emotional. And it's just best to, move on. So that's why when I talk about negotiations, we try to make it as quickly as possible so that the parties can just move on with their lives. So now we're going to discuss about assessing the damages. We talked about the amount of earnest money deposit provided, the time frame that it's provided, and that there was an acceptance of the purchase agreement. And then, unfortunately, there was a cancellation, whether it's contingent based or failure to perform, it canceled. So now that we're at the canceling stage, how much should you get, if at all, of the deposit, either buyer or seller side? So first we have the liquidated damages clause. And this is triggered by the buyer's breach, not by the seller's breach. So, for example, a buyer is unable to close on escrow because they either don't have the money, they don't have the loan, for some reason they just can't close. That is a buyer's breach. So that's when the liquidated damages clause comes into play. And at that point is when seller retains the buyer's earnest money deposits, but it cannot exceed 3% of the purchase price, and anything in excess is returned to buyer. So let me just, rephrase this real quickly. A seller only gets a deposit when buyer releases all of the contingencies, or there were no contingencies, and then fails to close escrow. So it's pretty specific on when seller is able to obtain the earnest money deposit. And, within the liquidated damages clause, it shall not exceed 3%. But we also have Civil Code Section 1675, which means amounts actually paid. So here are a few different scenarios. You have a buyer who submitted 10% of the purchase price as their earnest money deposit. Technically, in a perfect world, when a dispute occurs, the buyer and seller will provide escrow instructions to the escrow agent to release 7% of the funds deposited as the earnest money deposit back to buyer. So then the parties are just fighting about the 3%, because that's technically only what the liquidated damages clause provides. So they fight over the 3% and they decide either, buyer gets everything, seller gets everything. They split it 50-50, 60-40, 70-30, however. But that is scenario one of how to handle that situation. Scenario two is buyer submitted 2% as their earnest money deposit. Not 3%, they only provided 2%. So when they're fighting, seller might say, oh, well, you owe me not just this 2%, you owe me this additional percent because I get up to 3%. Buyer will respond, no, you don't. You get up to 3% if it was deposited but under Civil Code Section 1675, you only get what I actually deposited. So I only deposited 2%. That's all we can fight for. And I know there are arguments between the two of whether it's up to 3%, regardless of what you provided at the outset. But we've always argued it as based on how we read 1675. Civil Code Section 1675 is the amount actually provided. So if buyer only provided 2%, that's all we're fighting for. We're not going to even start talking about that extra 1% because it's not relevant since it was never tendered. So those are the 2%, two scenarios regarding the liquidated damages. And again, I put the release of funds as required. The release of funds, i.e. the escrow instructions, need to be signed by both buyer and seller. Okay, so there are other damages. I want to go back to the first slide where I put liquidated damages. And then this one that says other damages. Originally, I did have additional damages written there because some people do say the phrase, oh, these additional damages. That's confusing because it seems like, oh, you get liquidated damages and you get these damages. That's not true. You get liquidated damages or you get these other damages. You can't get both. So that's why I switched it to other damages. And when I hear people say additional, I try to, politely say, you mean other damages, because we can't add both of them. Or use the phrase consequential damages. So say consequential damages usually come up when the liquidated damages clause is not signed. So, and see, I even had additional damages on the slide in this little note section. So that should actually be corrected to sue for other damages, not additional, because we're not adding to the liquidated damages. It's either or. You get liquidated or you get consequential. So consequential damages come into play when the parties don't initial the liquidated damages clause, because in both the CAR form and the PRDS form, when you get down to the liquidated damages paragraph, it has a section for you to initial. It's not just automatic part of the agreement. You have to specifically initial that. Some people do, some people don't. And it's all because your knowledge about what is a liquidated damage clause. So in this instance, we're going to say the seller breached, and so they may be liable for broker fees, rent, or etc. And I personally am in favor of the liquidated damages clause because I believe it's beneficial for both parties. So I'm going to go back real quick. And so liquidated damages compared to consequential damages or contract damages. Liquidated damages, again, tops it off at 3%. So if a buyer, for example, buyer and seller enter into a contract for $100 and buyer breaches, they can't get the loan or what have you. They are in breach and they put $2 into the earnest money deposit escrow account. So seller then sells the property for $90 and is trying to go after buyer for that, the difference, which is $10. Well, the liquidated damages clause prevents that. So it prevents buyer from having to pay the $10 because they just say, no, we signed the liquidated damages clause. You are capped. I tendered 2% by giving $2, and that's all you're going to get. So you can keep the entire liquidated damages. You can keep the entire earnest money deposit based on the liquid damages clause, and I don't owe you anything else. So that's how it's beneficial for the buyer. How a liquidated damage clause is beneficial for the seller is roughly the same thing. So buyer breaches and seller sells the property for, let's say, $110 instead of $100. At that point, buyer is going to argue and say, you're not damaged. You actually sold this property for more, so I should get this money back. And that is a solid argument. The seller got more for their money, got more for their property. They sold it at a higher rate. It was better for them. But the buyer did breach. And so there is an argument for the seller to say, no, I get that no matter what because you're in breach. So it helps with just fixing it. So it protects seller it protects buyer from having to pay excess amount of damages, and it gives seller, a solid argument, because even if they do benefit from selling to somebody else for a higher price, they were buyer did breach, so they have a claim to such liquidated damages. And then we go to consequential, which is the contract-based damages. So back to the original example in which I said buyer and seller contracted for $100, and buyer canceled the contract, or seller canceled the contract, and then seller sells the property at $90. If the liquidated damages clause is not signed, then buyer could potentially be liable for that, the extra $10, and whatever other damages, because there is no cap. There is no stopping what's going on. And same thing in return, if the seller sells a property for $10 more instead of $100, $110, then their argument for that they were actually damaged is weakened, because they actually benefited from selling to somebody else. And so at that point is when we have to get into negotiations, because a lot of this is a lot of money. It is a lot of money. $10,000, $20,000, $50,000. The amount of money that people have saved and have put towards an earnest money deposit is a lot of money. It's just not a lot of money when you get into the litigation aspect of it. You don't want to spend $10,000 on attorney's fees for a $10,000 deposit. And so that's why when these disputes happen, it's best to kind of take a step back, look at the facts of what happened. Was it buyer's breach? Was it seller's breach? What exactly happened? Set up your argument on why you think you deserve it, and then really just start negotiating from day one, because you want this to just turn over quickly. You don't want to spend a lot of money on it, and you want to just move on. So you buyer might have a strong argument, and you seller might have a strong argument, but are you willing to put thousands of dollars worth of attorney's fees, to get this deposit? Or would you rather save the stress, attorney's expense, and emotional turmoil, and just say, okay, fine, we'll split 50-50? And the problem with this that I've seen is that if a buyer or seller, whichever party, really feels that they didn't do anything wrong and they deserve it, it is hard to just say, okay, I'll, give up 50% or a percentage of the earnest money deposit, because they feel that they are very much entitled to that money. But we're trying to get people to move on. We're trying to get people to buy their actual home, to sell their home and move on. We don't want this to turn into a litigation dispute over an earnest money deposit, because it's just, in a attorney's fees world, it is not that much money. $10,000 is not that much money to go through a full-blown mediation or litigation with an attorney. Mediation can cost up to $10,000, and that's from the commencement of your meeting with your first attorney, the mediation demand letter, preparing the mediation brief, and paying the mediator. Mediators are either retired judges or attorneys, and that cost goes up quickly. So we advise clients on what their rights are, what we think is a solid argument for them after reviewing the facts, and then, just say, what do we need to do to resolve this as quickly as possible? And so, because a fast resolution is best for all parties, because it distributes the funds and everybody goes home. And I want to clarify what a fast resolution is. Some people think if you call our office on Monday, that on Tuesday or Wednesday, everything's going to be resolved. That's not the case. We call it fast resolution because in our world, things take a year to 2 years. Before you go to trial, it could be a year and a half to 2 years, and potentially pushed out even longer. So a week to 4 weeks is pretty fast for us. I know that might not be fast for everybody, but that's why I wanted to kind of give an example of what fast resolution is for us, so that when, hopefully you don't have to ever be in this position, but on the off chance that you or somebody that you know is unfortunately in this deposit dispute, that they have a realistic expectation of how quick this is to resolve. So, for example, a potential client calls on Monday, set up an appointment for Tuesday with an attorney. They set up the appointment, meet with the attorney, then the attorney contacts the opposing party, whether it's their agent or their attorney. And they contact them either Tuesday, probably Wednesday, to be honest. On Wednesday, they call. They spend the next day or two coming up with a reasonable solution that they think both parties might be amenable to, because they talk about, the facts, what they have, what they are aware of, what they think they can really work towards for both of the parties. And then let's say it's Friday and they go, okay, we got a plan. Let's run it by our clients to see if that works. Tell the clients Friday. Buyer and seller then have the weekend to mull things over and see if that's something that they are interested in. Monday comes around, they each call their respective attorneys or agent and, have questions, because there's always going to be questions. How is this going to affect me? What does this do here? On and so forth. And potentially there might be some revisions to whatever was proposed last Friday. So there are some revisions. the attorney and agent, talk again on either Tuesday or Wednesday. They revise something again, think it's good to go, send it to both parties to see if that's acceptable. And depending on when people respond, it could be the following Monday where it's, okay, we got an agreement. So at that point, then you contact and the escrow agent to get the escrow instructions, fill them out, have the party sign it, send it to escrow, and it could be the following, and it could still be that Wednesday or Thursday. So my example right now was just 3 weeks, and it can be shorter and it can be longer. 3 weeks, I wanted to do that. So, because it's reasonable for 2 weeks to happen, 3 weeks is pretty common as well. And sometimes we've done it in a week. If parties are just, all right, we're good to go, no questions, no nothing. Let's just sign this and have the money distributed. That's great. Don't feel that you have, as a buyer, or seller, don't feel that you have to just sign whatever, comes your way. If you have questions, ask your agent or attorney. If you are not comfortable, tell them the reasons why. If you don't understand the law and how it applies to your facts, just ask. There is no harm in doing that. And it actually will help, bring the resolution quicker, probably, because there isn't this nagging feeling that you are not totally aware of what's going on and that you feel that it's just happening too fast around you. We don't want that. So that is pretty much my presentation on the topic with deposit disputes. And so I'm going to see if there are any questions. So let me just... Okay. So I'm struggling a bit. Clayton, if you wouldn't mind coming in, reading this, because it's not letting me look at the entire question as a whole. Okay, so it's a little bit short. Yeah, letting go. Okay, thank you. Okay, so this first question. Okay, so question 1 is Civil Code Section 1675 mentions a subsequent sale at or above the contract price. So what if a subsequent sale is for a lesser price, but the earnest money deposit is more than the price difference? Okay, so the subsequent sale or at or above the price. Okay, so what if a subsequent sale is for a lesser price and the earnest money deposit is more than the price difference? Okay, sorry for reading that twice, but I just wanted to completely understand the question. Okay, so we have the earnest money deposit. I'm going to use a $100 example again. Buyer deposited $2 and seller sells the property within 6 months for $90, because we're trying to do the subsequent sale is less. Oh, I understand. Okay. Back to my example. $100 purchase agreement, $2 earnest money deposit, and the property was sold for $99. So not that big of a difference, but it is less than what they would have gotten. Well, how I review it, and can be disputed, and if anybody wants to follow up later, I completely invite your review and perspective of it. the seller still gets the earnest money deposit because it is fixed and it was the amount that was paid for. The buyer can argue, and I think it would be wise for the buyer to argue, say, oh, seller, you were only damaged a little bit, so you should keep $1, but I should get my other dollar back because otherwise you are benefiting from this breach. And so with that, both sides do have solid arguments because in this situation, buyer did breach, and so seller had to sell. But it does make it where the buyer has a solid argument to get at least half of their earnest money deposit back because it would benefit the seller more than just the original agreement. But again, that's where we go to negotiations. How much are you willing to spend for that extra dollar in attorney's fees to get it back? So if anything, just start off with, let's do a 50-50 split. If seller says no, still work at it, but don't get to the point where you're spending more on attorney's fees than on the actual money that you're trying to get back, because it doesn't benefit you at all. Okay. So next question. And unfortunately, this is the last question since I've gone over time. If the buyer doesn't deposit the earnest money deposit, the liquidated damages clause is no longer on the table, leaving the buyer to unlimited damages. Is this correct? So I'm going to read it one more time. If the buyer does not deposit the earnest money deposit, the liquidated damage clause is no longer on the table, which means the buyer is leaving the buyer responsible for unlimited damages. Is that correct? The answer is no. So again, with 1675, it's the amount deposited. So we're going to go back to one of the very first slides in which I talked about the amount of days, the default days in which a buyer has to submit the earnest money deposit to escrow. Default is 3 days. So say the buyer never did that. Well, if the liquidated damages clause is signed and the buyer never submitted the deposit, then it doesn't terminate the liquid damages clause because it's still there. Everybody signed it. It's just, unfortunately, it's zero. The seller would get zero because zero was deposited. As I said previously, there are arguments where some people have claimed that it's up to 3%, meaning that they get up to 3%. So in that situation, the seller might say, buyer, you did not deposit the money, but I get up to 3%. Well, the buyer side is going to say, no, you don't. Under Civil Code Section 1675, you only get what was actually deposited. I did not deposit anything, so you get nothing. So just to clarify, if a buyer does not deposit the earnest money deposit, it does not invalidate the liquid damages clause. It's still part of the contract. Okay, so that is my presentation. If you have any questions, please feel free to send me an email or give me a call. If you have any other comments as well to maybe branch this out even more, if you wanted me to focus on something else, then I could, do that potentially for another webinar. Give me a call or send me an email. I'd like to thank everyone for participating today, and I hope you enjoyed it and learned a little something about deposit disputes. Okay, thanks, and have a good day.